Okay, hi everybody. My name's Hannah Taylor. I'm a partner at Frankfurt Kurnit and co-chair of the advertising group and blockchain group in the USA. And I am here with my esteemed colleagues, Rolf from Switzerland. We have Alan from the UK, we have Valdir from Brazil, and we have Donata from Italy. So today we're going to be talking about probably the newest craze that all of us have heard about over the last few years, NFTs, crypto, and the metaverse, and how us as advertising lawyers need to think about these issues. So we thought we would start today with a hypothetical, and we are pretending, instead of sort of talking about all the different country issues specifically, we're pretending that we're all representing a company. And this company is called Miss Cookie, and she is going to have a brand called Happy Treats that she's going to launch. And Happy Treats is famous for its shortbread cookies, which is why each of you now have Miss Cookie's famous shortbread cookies, or should be eating them as we speak. Tell us how they are. And Miss Cookie has a character on the front of the cookie. And that character's face is based on the CEO of the company, whose name is Ann Kim. So what's the plan? What are they going to do? They decided they want to jump into the metaverse, NFTs, and crypto, and they want to decide to engage with consumers in this new way. So they have a few key things that they want to work out. The first is they're going to obtain some land in a metaverse world. They're then going to hire virtual influencers, each of which is going to have an avatar to promote the activation. They're going to do a Miss Cookie NFT Drop. And to make it even more exciting, each NFT is going to allow the holders to get 1 free year of digital cookies. And it's also going to perpetually give 5% of proceeds back to the digital artist who created the art for the NFT. And then, of course, because it's an advertising activation, they're going to promote it to the hilt, right? Okay, so now what? How do we think about this? Now, I want to think first about the law that's at play, because one of the things that many people say when we're all counseling in these areas is there a law of the metaverse, and how does that all work? So I'm going to ask each of my esteemed panelists to give a few thoughts on, what would we do? Where do we ground ourselves if Miss Cookie comes to us and asks us to help out here? So Rolf?
Well, I think it's similar to the internet. There is no law as such that applies to the metaverse. But national law will apply depending on the situation. No? I mean, in the relationship between a company that has activities in the metaverse and customers, it will be the consumer law in most jurisdictions, the local law. Then you have terms and conditions that you enter into with the platform that is running the metaverse, and these are mostly offshore jurisdictions, or in the case of Decentraland, I think it's Malta, the laws of Malta that applies. Also, the actual foundation that runs it is having its domicile in China. So it's certainly kind of a challenge to give
Absolutely.
A general answer.
Yes, and they're Decentraland in particular is a decentralized autonomous organization, so good luck finding a human being to serve a lawsuit to. Alan, what do we think about in the UK? How do we think about all this?
It's very, very similar to what Rolf has said, actually. There aren't, there are lots of laws which deal with, use on the internet, but there's no one particular law. In the UK, we've been talking a lot about the online safety bill that's sort of been going back and forth, and government, this current government is due to review that and whether they push it forward. But, the point, and we touched on Decentraland there, the point, I suppose, is that there are many metaverses, and therefore, this play for brands, Miss Cookie, to play and deal in other metaverses means that we need to be thinking about the terms and conditions of not one metaverse, but multiple metaverses, multiple platforms, and the jurisdictional issues that come with that. That's probably the key thing for me.
Absolutely. And I wonder, before we go to Valdir, if are there any sort of, like in America, for example, we not only think about sort of jurisdictionally what applies, but we're also worried a lot about consumer protection. We're worried about the financial regulations. We're worried about commodities rules, all sorts of things that probably as advertising lawyers we're like, I don't deal much with securities, and now it's a huge part of what I do is thinking about these issues. Is the same thing true for both of you, that you have different types of bodies interested in this area?
Yes, and Switzerland is actually quite advanced, I think, in terms of regulating the distributed ledger technology-based securities, due to the fact that the canton of Zug, which is famous for pre-metaverse business advantages, declared itself as the crypto valley and really pushed forward, and also had lots of ICOs happening in that particular very small canton. But then the federal legislature was under pressure and actually issued under financial market regulations a law that acknowledges these DLT based securities, and also the Code of Obligations was amended last year to facilitate the transfer of crypto assets.
And would those crypto assets include things like non-fungible tokens?
Yes.
Okay, interesting. And Alan is...
Yeah, I mean, it's the Financial Conduct Authority here, the FCA, is really quite sort of hot on this, and it talks a lot about crypto assets and has a different sort of way of whether an NFT would fall subject to that, but, erring on the side of caution, possibly. And obviously, if it becomes a regulated asset, then like other regulated businesses, you have lots of compliance to do. So it's a hot topic.
I know, whole new world for advertisers. And Valdir, how about in Brazil?
Well, it's the same in Brazil. The existing laws would apply, but we do have new regulation on taxation of capital gains on the resale of crypto assets, such as an NFT. If you buy an NFT that costs more than £1,000, you have to declare it to the IRS, and if you resell it with a gain, you have to pay capital gains. The control of this is going to be challenging for the IRS. And yesterday, the Brazilian Stock Exchange Commission issued a legal opinion, a 22-page legal opinion, explaining on how it intends to deal with crypto assets that are considered securities. So these are the only pieces of legislation that refer to crypto, NFTs, and the Metaverse. The rest is, the IP laws and conventions, etc.
Yep. And Donata?
Well, in Italy, we do not have any law or regulation specifically governing or concerning NFTs nor the Metaverse. So their possible legal qualification currently falls within a sort of a big gray area. We do have a law which provides for a legal definition of blockchain and of a smart contract, but only in connection with the legal value of the electronic document that you save on the blockchain, so something really technical. And moreover, we are still waiting for some technical rules to shape the applicable legal and technical framework. So these provisions are currently not fully enforceable. So currently, the advertising and sale of NFTs in Italy are subject to general principles of contract law, consumer protection law, and of course, advertising law. And by way of interpretation of the provisions of the Italian Consumers Code, the NFT might be qualified as digital content just because the definition of digital content provided by the Consumer Code is extremely broad and it comes from EU directives. It is basically digital content is any data produced or supplied in a digital form. So it seems that an NFT might be considered as digital content, but we have no confirmation so far by the case law or commentators and so on. It seems reasonable, let's say, and we would have some rules to apply in order to protect consumers. And as to the question on the law applicable to the platform, it might be that the law chosen by the parties pursuant to general principles of contract law and consumer protection law. However, similarly to other countries, an Italian consumer purchasing NFTs must be granted with the minimum protection provided for by the Italian Consumer Code, since the provisions are somehow mandatory in nature. If more favorable compared to the law of the platform, so the law indicated by within the terms and conditions of sale or of the use of the platform, the consumer code would apply. And if advertising is made, of course, Italian advertising law will still apply. It is not clear so far if the NFT may be regarded as a financial product or not, and in this scenario, of course, additional provisions also in connection with advertising would apply.
Interesting. I like to say when I counsel on NFTs that they're like an empty box, and same with the metaverse. It's like, it doesn't mean anything until you start to do something with it. So you can have a situation where an NFT is basically doing nothing other than acting like a ticket to an event, or you can have an NFT that's used to fundraise. And so NFTs themselves, it's like saying, how do we regulate, Microsoft Word? It's like, well, that's just technology. How you use it is how it really gets regulated. So I think that's clear from all the panelists that that's really what we're going to see regulators focus on, is the use case for the technology as opposed to the technology itself.
And it's interesting to hear that the tax authorities first came across the NFTs before they were acknowledged in the legal system in Brazil.
Yes, and in America we have actually a similar thing, although we'll get to it in a bit. We have a lot of regulation by enforcement as well in the United States, where we don't, much like many of the other countries mentioned, we don't have necessarily any crypto-specific guidance. President Biden has issued an executive order asking each of the various federal agencies to issue reports to him on what they plan to do of how to regulate it, but we don't have any clear guidance quite yet. And so what's happened is each of those various federal agencies are bringing enforcement actions that are sort of guiding the industry to figure out exactly what to do, and we'll talk a bit about that. Okay, so the first plan was buy space in the metaverse. That sounds, easy enough, right? But I think the first question is, what's the metaverse? And some of my panelists mentioned this, but one thing to note, just from a tech perspective, is that, as Alan said, there is no such thing as the metaverse. I think we're all hoping that one day that gets created, right? That's the future, the promise of the internet. But right now, it's essentially just a series of platforms that are offering spaces for brands to virtually engage with consumers or their avatars. And as many of my panelists mentioned, that means that we're going to have to think about lots of the same things we've thought about with platform law forever. What terms apply? What can you do on the platform, and what can you not do? So let's talk a bit about what to do with this initial activation. Okay, so Rolf, what should they think of when they're choosing a metaverse? What should they think of when they want to buy space? What do you think matters here?
Well, first we'll find out that there is plenty of metaverses, at least 20 that have a decent followership, but I think two of them that really stand out where most companies and advertisers currently invest. It's Decentraland, which has issued about 160,000 land certificates. You can buy land, virtual land, in the Decentraland, and then set up your presence there and start selling cookies, like Miss Happy Cookie is doing in our case. And the second one is Sandbox. The first one is controlled by a foundation in China, the second one by a company in Hong Kong. Also, they now have operations all over. So, but in the end, yes, they're all operated by someone sitting on the ground and making business strategies and decisions. But I think it's really worthwhile making a proper analysis of which metaverse is the best to set up a presence, to spend advertising money, also to make sure that you find yourself in a brand safe environment, not next to activities that would do harm to your brand. And then you can also consider maybe first leasing land instead of buying, but then you even have less control over what you actually can do there. So I think the best strategy is to buy land, just to start making experiences and not think about really monetary returns. I think right now all the activities that we are seeing in the metaverse are for marketing purposes, and if they are exploited off metaverse in a intelligent manner, then I think they can generate quite a lot of brand value. Even ourselves, our firm, we will hand out an NFT for Christmas to our contacts and clients
wonderful.
this year. Yes.
One thing that I think is particularly important to understand, and was new to me when I, first jumped into the whole metaverse topic, is that various metaverse platforms work differently. So, because there's no such thing as the metaverse yet, we're seeing this real sort of divide in how the technology is happening. There are what I would like to call Web 2 metaverses, which basically just means, think about Roblox or Fortnite or other games that have existed for years that have nothing to do with crypto. They have nothing to do with the blockchain. They're essentially just a platform licensing to you a space on which you can build additional products, right? And for a legal purpose, that's not that there aren't tons of things to consider, but there's not anything really new or innovative that should concern any of us. Where the real innovation has happened is, as Rolf mentioned, the what are called Web 3 metaverses, which basically means that the front end might look to all of us or to an average consumer like the same platforms that we've always been using. But what's happening on the back end is that the database that's keeping all of consumers' data, or the way that the whole platform functions, is not run by any one company. It is run by and hosted on the blockchain, which, as many of you probably know, is a distributed ledger that, depending on what blockchain the tech company uses, is distributed all over the world and maintained in a public and immutable way. And so it's very different, if you want to buy land in Roblox and you want to invest there, that is a very different legal proposition than trying to buy land in a company or a platform like the Sandbox or Decentraland, where in order to buy the land, you need to have a digital wallet that allows you to buy their native cryptocurrency. You need each of the pieces of land as its own non-fungible token. That is a registered piece of code on a blockchain that links with a URI back to their front end. They don't control all of the data that's on the back end. And their promise to you is that you own the asset that you're creating or licensing on the blockchain. So what that means essentially is that I could create an avatar theoretically on Decentraland, and I could then own that avatar such that I could remove it from Decentraland and sell it on an NFT marketplace. It becomes, according to them, my own property. The thing to really keep in mind, though, is that all that you really own is the non-fungible token, which is just a little piece of code that sits on the blockchain. They still license to you all the front end. So the fact that your avatar can move, the fact that it looks a certain way, all of that is functionality that's licensed to you. So it's great that you own the land or you own your avatar, and it is true that it's potentially interoperable or resellable, but it also could potentially be rendered worthless to the extent that the front end that they're licensing to you ceases to operate, or you're kicked off the world. And so from a consumer protection standpoint, which we've talked about a lot, it's really important as lawyers to understand what exactly is going on, what we call under the hood, so that you can know, if you're telling a client, like, yes, you own this land, the extent to which that's really happening. And we'll talk a bit about some of the other tricky IP and other issues with some of these worlds. So, okay. It's not, the sort of tech issues are not the only things to contend with. We also have to think about what's happening once you're in the world. So, Donata, do you want to talk to us a bit about, how do we think about what's happening inside this metaverse space?
Yes, it's not one of the issues is that it is not so clear when you are advertising on the metaverse. And I think that some principles that we have in Italy in connection with the in-app advertising may be of some relevance also in connection with the metaverse. Because in Italy, both the Italian Advertising Self-Regulatory Body and the Italian Competition Authority have issued some guidance in connection with in-app advertising. Specifically, the Italian advertising self-regulatory body, which enforces its own code of commercial communications, has inserted a specific rule within the so-called Digital Charter regulation, which is a regulation entirely focused on transparency in online advertising. And such rules provide that if the content of an app has even wholly or partially advertising nature, the user of the app must be informed that the content has been sponsored by the advertiser. And similarly, the Italian Competition Authority, which enforces the rules of the Italian Consumer Code concerning unfair commercial practices, so also those concerning hidden advertising, has opened several proceedings in the recent years against apps operators which made available on platforms app which allowed in-app advertising without informing the consumer in advance. And the authority stated in these decisions that it is necessary for the user to become aware of the circumstance that by downloading and by using the app, in-app purchases will be allowed. Also thinking about the use of this kind of app, which basically were apps for playing games, let's say, so are kind of app which is used mostly by kids. So thinking also about kids, it is important for the parents to know whether by allowing the use of the app by even a minor, the minor is able and in a position to make a purchase. So it is important, and one of the principles is to make a disclosure on the platform which allows the download of the app, so that the consumer is informed. Of course, our authorities have not taken any position about the Metaverse, so these principles are, in my opinion, applicable or reasonable, let's say, by way of interpretation. So we are waiting for some guidance by our authorities in connection with these topics.
I'm sure it's coming. And Valdir, how about in Brazil?
Well, as you mentioned, kids, and if you use the Meta Quest 2 goggles, the terms and conditions say that they should not be used by kids under the age of 13. But if you read a very recent article that was published in the New York Times a few days ago, the journalist, a woman who has little kids, she used the goggles and she navigated the Metaverse platforms for several days. Every night she did it for several hours, and she bumped into a lot of little kids. So this is a major concern for the platforms, you know, how to avoid, and for agencies and advertisers, because we're going to advertise in this space where kids will be. So it's a major concern.
Absolutely. We have the same thing in the United States, where we have a consumer watchdog organization called Truth in Advertising, or TINA for short. They sent a very detailed complaint to the Federal Trade Commission recently about Roblox and the fact that when kids are on Roblox, they often don't understand when they're being advertised to, or they walk into a specific space and don't understand it's a branded space, and that each sort of room is not appropriately labeled as advertising content. So it's very similar to what we saw in 2015 with the native advertising guidance. People are starting to think about that again, and particularly because these spaces are so attractive to children. But there's also an issue when it comes to open source as well, right? It's not just transparency issues. So Rolf, how are these sort of worlds built, and what do we have to think about from that perspective?
Well, most of these platforms are built on open source technology, and but then when brands are, for instance, then creating a presence in the metaverse and doing creative works, that is obviously also protected by copyrights, and also maybe brands will be involved. But as lawyers, when we draft agreements with the agencies, you know, usually the advertiser likes to get all the rights in the creatives and then in the underlying code, and that may not be possible depending on the metaverse that actually is being used. So I think I have to be careful to not to overpromise to advertising clients to what they actually will get in the metaverse.
Absolutely. And some of the terms, given the fact that they're based on open source licenses, even have restrictions. So you have to think about like how to put, at least in America, how to put copyright notices on things appropriately in accordance with the terms. So it can be, kind of a tricky thing. Okay, so let's do part 2 of the exciting Miss Cookie activation. Is going to be virtual or fabricated influencers, as the Federal Trade Commission calls them. These are our 4 avatar influencers. So, all right, we know a lot probably at this point, and we'll learn a bit more later from Allison's panel about influencers. But what do we need to think about when it comes to Web3 type stuff, and what's the sort of difference? Valdir, will you talk to us a bit about thinking about virtual influencers in this space?
Yes, in Brazil, 95% of the cases are decided through CONAR. Most of the Latin American jurisdictions have a self-regulation body called CONAR, and so do we. And the cases are decided through self-regulation. And CONAR has some guidelines which were published in 2018, regulating the use of the use of influencers by advertisers. We have more and more influencers in Brazil, celebrities, soccer players and singers, etc. And many of them were not disclosing that they were sponsored. So they do have to use the hashtag publi or publicidade, or in English hashtag ad, or hashtag sponsored. Otherwise, the advertiser could be penalized. CONAR cannot issue fines and doesn't have a police power, but the case could be taken to a state consumer protection agency, and they could issue fines.
And would the same thing apply to an influencer that was a bot or not real?
Yes, we have recent cases. A chain of retail stores created a digital influencer that is also a virtual influencer, not a person, a cartoon character created through AI, in artificial intelligence. And the rules apply to her because she talks like a person, she looks like a person, and she represents the company. Okay. So, and there's another interesting case, which is a TV celebrity who is half Japanese, half Lebanese, but she's Brazilian, and she created her own avatar, and she licensed to the biggest Brazilian bank. And they activated it during the Rock in Rio festival. So the rules apply to both.
Exciting. Donata, does it matter to consumers that these are bots or are made from AI? Is that something consumers need to know?
Well, in principle, it should be quite obvious to the consumer, but actually it depends. I mean, it depends on how the platforms look like, or it depends on how the virtual influencer acts or interacts on the platform. I would say that there is not an legal obligation, of course, to make such a disclosure, to indicate to the consumer that the influencer is a virtual one. But I mean, all of this is new, so of course there is not a legal obligation. On a certain perspective, under the general principles on transparency in advertising, it may be advisable to make a disclosure not just about the circumstance that the influencer is virtual, because it should be quite obvious, but rather that there is a relationship between a commercial relationship between Miss Cookie and the virtual influencer, because we said before that the influencer has been hired by Miss Cookie, so there is an agreement between Miss Cookie and those who manage the rights on the character, so on the virtual influencer. So this may be something to be disclosed to the consumer, because in Italy, of course, in connection with traditional influencer marketing practices on social media, So when real influencers are involved, if there is any kind of relationship, of commercial relationship between the brand and the influencer, even in the lack of a written contract. So just for example, in case of a supply of goods in favor of the influencer, without an obligation to make a post, but then this happens because the influencer decides to make a post showing the products. This is advertising. It's not regarded as a personal endorsement, as truthful endorsement by the influencer. So the approach taken by the authorities is quite protective in favor of the consumers. Of course, in the lack of this kind of relationship, the influencer can choose, the real influencer can choose to use a product to make a positive post about it. This is not advertising and no disclosures are needed. But when in the case of virtual influencers, as to the question on the possible truthful endorsement, it's not possible to make a personal endorsement because you are not using the product. And moreover, there is the commercial relationship with Miss Cookie. So I would say that no, it's you cannot be a truthful user and endorser of the product.
It's interesting. In the United States, we have updates to our guides on endorsements from the Federal Trade Commission that are coming soon. And one of the things in their proposed guidance that they're going to update is actually including virtual or fabricated influencers as those who count as influencers under the guide. So that's a big change for us. The other thing to note is that in the complaint against Roblox that Tina sent to the Federal Trade Commission, one of the things that they specifically noted was that many of the rooms inside Roblox contain famous celebrities or avatars of various people who've paid to be there, and people don't understand that. And as lawyers, you know, we've thought so much in recent years about what it means to make a clear and conspicuous disclosure, and does it have to be in the first 2 lines of an Instagram post? And we're now going to have a completely different way to think about this as we think about how to move through these worlds and how to make it obvious that somebody has been paid to be there. One of our clients suggested that the virtual influencer wear #ad on their t-shirt. But there's not a place. And the same thing was true for native advertising. We have to get very creative about what it means to be both clear and conspicuous, or to the extent there are different rules for each of you, how to make it obvious to consumers that all of this is happening. Okay, so now we're on to the NFT drop, the big kahuna. As you can see here, this is a very exciting generative art project, very valuable. As you can see, each consumer is paying $1,500 for one of these amazing digitally rendered art pieces. So, of course, they're quite valuable. The way that Miss Cookie did it was that each of these pieces of art is different. They each have different traits, and they're generated by a computer and have a rarity scale. It's very rare to get one with a black hat and red cheeks, for example.
And it's good to tell the audience that the initial plan was to make real cookies and deliver at the houses of the customers, but then we would have a logistics problem to cover 100 jurisdictions.
Yeah.
And
How do we
thought
deal with food law?
More profitable to sell the digital cookies than the real cookies.
Exactly, more profitable. So as part of their NFT drop, consumers are going to get a few different things. They're going to get a license to this fantastic art, and then they're going to get a year of free digital cookies, which, as Valdir mentioned, is potentially less desirable than a year of physical cookies, but we did not have time to talk about food safety on our panel, so we made it a bit simpler in the hypothetical.
But the cookies that we handed out today are completely safe.
Yes, they are.
Cookies, and they were not meant to be eaten here.
Yeah, exactly.
They're homemade.
They were meant to be a takeaway, because
Yes.
we're not so sure if all of you can really take a lot home from the panel discussions, because as you notice, a lot of things are still unsettled and require creativity
It's
of
true.
the
We're
lawyers.
getting cookies because we don't have firm legal answers. Exactly.
Yes.
Yeah. Okay. So one of the things that's going to happen when Miss Cookie does an NFT drop is she's going to also give the artist that created that beautiful generative project 5% of the royalties every time the NFT gets transferred along the blockchain perpetually. And I keep using quotes, and I'll explain a bit why. So one of the things that I also think is very important to understand when you're counseling in the space is to really get what an NFT is and what it is not. So I find this visual to be very helpful. It really helped me in my understanding of how the technology works. So in this situation, the artist is the digital artist who created those cute little hat cookies, digital cookies. The photos of each piece of digital art is considered the media. The artist is going to go to what's called a token generation app. You may have heard of OpenSea or Rarible or one of these other NFT marketplaces, but there are many of them. And they're going to do what's called mint the NFT, which is essentially just execute code onto the blockchain. Now, what happens when they mint the NFT, what makes an NFT non-fungible or different from other types of cryptocurrency, is that it has inside it specific metadata. And that metadata contains something called a URI, which is basically like a sister to a URL. And that token points to somewhere else on the internet, not on the blockchain, but somewhere else where that art is stored. So when you create an NFT, the art is not the NFT and the NFT is not the art. All that's happening with the NFT is just a little piece of code getting executed, and the internet is linking that back to a place where you've stored that digital art somewhere else. Now, all of this is done and executed through smart contracts, which I hate their name because they're neither smart nor a contract. They are essentially self-executing pieces of computer software that answer if-then statements, and once certain conditions are met, certain transactions get executed. They are not pros attached to a token. They can't understand what is as mutually agreed by the parties, or they're not sophisticated at all. They're basically just little pieces of computer code. And once the smart contract executes the token then points back to that art that's stored somewhere else. So in Miss Cookie's case, the NFT sits on the Ethereum blockchain, and the art we have to upload somewhere else. And that's something we're definitely going to think about as part of our process. So, okay, this is a lot for consumers to understand, and it's a lot to tell them what we're doing here. So how do we figure out how to enforce all this or tell people what's up? Donata?
Actually, in Italy, this is one of the biggest issues, or at least of the mostly discussed issues under the consumer protection perspective, because we do have rules within the Italian Consumers Code concerning distance contracts, which derives from EU directives, in any case, and which requires that the consumer, before being bound to any distance contract, is provided with a series of information concerning, for example, the product that is about to purchase, the price, the applicable warranties, right or withdrawal, and so on. The aim is, of course, to allow the consumer to make an informed purchase decision. So the issue is, when NFTs are involved, how to duly, effectively, and exhaustively communicate with the consumer about all of this, considering that the mechanisms underlying the NFTs and the sale of the NFT, the blockchain and the like, are really complex, and some of them are purely technical in nature. And so it may result to be quite complex and hard for the consumer to fully, deeply understand all of these aspects, which might result to be even confusing for the consumer. And moreover, the authorities tend to use the parameter of the average consumer, as most of the other jurisdictions, to assess if the information provided to the consumer are enough. So if the pre-contractual information are duly provided to the consumer. So it is still a big issue and an open point in Italy. For sure, the main tool available to the professionals selling NFTs to communicate with consumers is the document which includes the terms and conditions of sale, of course, which must be extremely clear in connection with all of these aspects. So what the consumer actually buys, what the consumer does not buy, so all the applicable limitations. You can see from the slide that there are some peculiarities for NFTs, some fees which the consumer does not know out of the NFTs environment. So the most appropriate location for all of this information, for sure, is the document with the terms and conditions of sale, which, moreover, in Italy, to meet some other requirements under the rules on distance contract, is sent to the consumer by email after the purchase as a confirmation of the concluded contract. So the aim is to allow the consumer to access the document even after the purchase, to check some more tricky, close, and so on. So I think that in this case, it would be actually the most appropriate location.
Yeah,
This is
hard to do on the blockchain when you don't know who anybody is, right? I know.
But also it raises the bar of who can be considered the average consumer. It will not be the elderly woman who usually goes to the market to buy her fruits. You need to have a wallet.
Yeah, but in any case, in Italy, NFTs are talked about for a really long time now. However, it still is a really complex topic, and the parameter is not the one of the average of the experienced NFTs purchaser, which in any case are really a few.
Yes. And one thing to also note is that I might be a brand who sells this NFT on OpenSea, and I do an amazing job of including terms and conditions that are applicable to the sale on the primary sale. But anyone who buys it can take it and sell it on a new site, right? They don't have to resell it on OpenSea. They could resell it on Rarible. And then all of a sudden, all the terms and conditions that I've beautifully placed here are completely removed, and the next person who buys it sees nothing. So one of the big business solves that's happening on the sort of business of law side are people who are trying to figure out how to affix to the token itself in a clear and conspicuous way, no matter where it moves, terms that consumers can see, so that they're solving for this exact problem. And Alan, what should a consumer think that they're getting vis-a-vis the art? Like, you know, we're talking to them about the value of gas fees that might apply, but do they think that they can just take that cookie and, you know, build a brand out of it? How does that work?
Well, that's the really the interesting thing, and actually we're seeing a lot of issues around that, about sort of people, you know, confusing the token with the art, and I think also brands getting that wrong. It's not just, you know, purchasers of NFTs. You know, for a brand like, I suppose, Miss Cookie and any brand sort of wanting to sort of play in this space, we do absolutely have to wear our IP hats and think about clearance from, you know, the sort of logo to all of the different artworks. And, you know, assuming we had engaged a digital artist who had a bit more creativity than the coloured hats that we saw, then we might, you know, be thinking about, you know, using celebrities or other, you know, third-party rights as part of those sort of NFT artworks, and therefore what implications does that have, and what terms and conditions are attached to that use and that kind of clearance. So there are lots of issues to think about, but I suppose the point is it's not really different to any other IP kind of clearance process when we're thinking about, you know, advertising or use or clearance of brand rights. Yeah, I think in America, at least, one of the big considerations is where it falls on the First Amendment spectrum, because we have some people arguing all an NFT is exactly like hanging a piece of art in a gallery. And just because it's sold, much like a painting might be in a gallery, doesn't mean that it's automatically under the commercial speech laws. So we're starting to see lawsuits come out of those types of considerations in the NFT space as well, which I think is really interesting. Just in the interest of time, I don't want to spend too long on the anonymity slide, but we mentioned this when it comes to sending someone an email. One thing to remember about the blockchain is that most transactions on the blockchain are either anonymous or pseudonymous, which means that you don't necessarily know, unless you're doing something, like gating it somehow, who you're transacting with. In America, that has serious implications for violating sanctions laws, where we're not allowed to do business with people on known terrorist lists or other bad actors. So brands have to think about how not to violate those laws. And I know, Rolf, you have some, Donata, you also have some thoughts on the anonymity slide as well.
Under the consumer protection perspective, because one of the information to be provided to the consumer before being bound to the distance contract is the identity of the professional, and the professional is defined in very broad terms as basically anyhow acting, any person or entity acting for the purpose of its business, let's say, on commercial activity. So the seller of the NFT for sure falls within this broad definition, and as you mentioned, most of blockchain transactions are anonymous. So the purchaser does not know the identity of the relevant seller. So this is still an open point, how to coordinate with this legal requirement with the technicalities of the NFTs and the blockchain environment. One possible approach may be to consider that the rationale of this requirement is to provide the consumers with the contact details of a professional who can receive any request of assistance by the consumer, any warranty claim or the like. And on marketplace platforms, the professionals actually are two. The NFT or product seller and the platform itself, and the platform is never anonymous. So in principle, this issue can be fixed. In principle, only in principle, may be fixed in case the platform is the entity towards which the consumer who can address his claim. However, this is not what happens, because almost all of marketplace platforms, not only of NFTs, in general of any kind of product, used to declare themselves as totally external to the sale relationship between seller and purchaser, and as totally not liable for anything concerning the sale. So the issue is not fixed. This is not an open point. We will see if something will change when the Omnibus Directive will be implemented in Italy, because the Omnibus Directive, as you may know, is a directive basically aimed at adjusting and updating national consumer protection rules to digitalization, so somehow to modernize their content. And some additional provisions are included as additional information obligation upon marketplaces. So we will see if something will happen in that context. We have not implemented.
And it's amazing because you can give yourself away, like, I am, Coke, I am Hasbro, I am the seller of this NFT, but then as soon as someone resells it, they would have the same obligation, and it gets quite confusing. Okay, so Alan mentioned IP. I think for NFTs, one of the most exciting things we can think about. So I like to think about it, and we talked about this as well, as sort of inbound and outbound, right? So inbound meaning, much like Alan mentioned, do you have the rights to everything that you need that's inside the artwork associated with your NFT? So Valdir, do you want to talk a bit about what we think about there?
Yeah, there are two main IP issues related to the metaverse and the use of and the sale of NFTs, in my opinion. One is copyright. NFT is a solution for the resale rights, droit de suite in French. And but in this case, it's going to be difficult to implement it, at least in Brazil, because it applies to the original work, and we are gonna mint thousands of NFTs. So we the company, Miss Cookie, keep the copyright because the copyright was assigned by the designer. So in Brazil and in France, in some civil law jurisdictions, the designer will keep the moral rights. Not in US, not in UK, but in civil law jurisdictions, yes. But our company, Miss Cookie, will have the economic rights, and we can sell them. But the resale rights in this case are kind of a gray area. And the other issue is trademarks. There is a lot of infringement on social media, and there are takedown notices. All the social media companies have takedown systems. The metaverse platforms should have the same. They're not prepared for that yet, fully prepared, but they should have the same. And so where should the companies register their trademarks? Because not all companies that are on the metaverse have registrations in class 9 or in class 35, and they're going to need to file that. But where? In all jurisdictions, 200 countries? No, we recommend to file in the jurisdictions where most of the platforms are domiciled, the companies that own the platforms, usually Panama, Malta, the Cayman Islands, etc. So these are the main IP issues, in my opinion.
Yes, and we also have to think about what we give to consumers, right?
Yes, I think some of them, at least, if they pay some money, they're interested in knowing what they get, And it depends on the IP strategy that you're implementing. It could be either a permissive strategy, to enable buyers to actually make use of the underlying artwork, for instance, for their own communication on social media networks, or even for their own commercial purposes. or if it should be rather restrictive so that they can only use the underlying artwork for their own private use. And the problem is that the NFT itself cannot contain the contractual terms, the license terms, under which the underlying artwork is made available. So that is usually placed in an agreement that is entered into with some kind of click wrap mechanism, which can be valid or not valid. We don't have to discuss the details of this here. But one interesting concept is that there is an open source license that has been specifically developed for this purpose, the Can't Be Evil NFT license. And there you can choose one of the different license types. It can be either for private use, can be for full commercial use. You can place some restrictions, for instance, that the underlying artwork cannot be used for hate speech purposes. So you're able to specify the applicable license, and the reference to that NFT license can be programmed into the NFT as part of the metadata.
I love that. I love it. It's like they're thinking, this is one of the things that's happening. Everyone's innovating every day. So if we have this panel next year, it will all be different. Sorry to say. Well, okay, so Valdir mentioned this a bit, but I want to ask Alan for a bit more on this as well. What do you do if you find out that Miss Cookie goes on OpenSea and sees that everyone else is selling a similar cookie NFT? Could she do something about it? Can she enforce against it?
It's a really good point. And we've already touched sort of upon, I suppose, the anonymity of these kind of marketplaces and people buying NFTs. And actually anyone here in this room that's been on OpenSea or has bought an NFT or has a crypto wallet, it's just a series of codes. It's very difficult to work out who owns them, who's behind them. So there is that fundamental problem with infringement about who do I send a cease and desist letter to? Who do I contact? Where are they based? Like all other platforms, really, I suppose, it's starting with the takedown procedures is the best and probably most effective way at the moment of dealing with infringements. There's obviously OpenSea has a good sort of process of doing that. Sometimes when you look at sort of the US approach, it can be, and you'll know more about this obviously than me, but the takedown procedures can be quite copyright-led and less so on the trademark side. And so some platforms, if it's a trademark issue, will accept service of basically a cease and desist for a trademark issue and do it like that. But I suppose that's currently the main mechanism.
Yes, A+. Welcome to the United States.
Yeah. So the leading metaverse platforms, they all have their notice and takedown procedures in place, but the additional challenge is that the infringing copyright work may be stored on the interplanetary file system.
Yeah, so tell the audience, what's the interplanetary file system? Can you guys believe that that's really a thing that we're talking about? The interplanetary file system? Yes, this is where we are.
IPFS, yes, that's the most used way to store the underlying artwork nowadays. Because the NFT does not contain the artwork, so it has to be, as you earlier pointed out, it has to be stored somewhere where it is accessible, and the NFT will point to that location if it's an individual server, or to the content if it's placed on the IPFS. Then you don't have a specific server or URL where the content is sitting, but it's distributed around the world on millions of servers. And there it becomes really challenging to get an infringing copyright work effectively down. I think it's currently almost impossible.
Yeah, and you can, remember that string between the NFT and the art? You can ask one of the platforms to basically cut that string. So the art's still sitting, as Rolf said, on the interplanetary file system, and it does still sit there, but it's no longer connected to the front end of a marketplace. It's no longer connected to the NFT, so it's functionally down, but you can't take anything off the interplanetary file system.
Not yet.
Yeah, not yet.
We're back in the days of the file sharing platforms.
Exactly. Now we're back in Napster. Yeah. So I want to be mindful of time. One of the really cool things that NFTs come with is what we call in the biz utility, which basically means that owning the token is not the whole thing you get. You get something else. As Rolf mentioned, one of the most exciting things that some consumers get when they buy a Bored Ape, for example, many of you might know about the Bored Ape Yacht Club NFT project, they get, when they buy the token, not just the right to own a very valuable non-fungible token, but a full, exclusive, perpetual, as long as they own the token, right to commercialize the artwork that's associated with their NFT for any reason. So that means they could make a movie of their Bored Ape, they could make a comic strip of their Bored Ape, they could do anything they want. Obviously, given how famous the ape mark has become, or it's actually probably not functioning as a trademark anymore, given how diluted it is, but it's amazing that anybody who buys that token can get that. But utility it can come in other forms as well, like getting a year of digital cookies or getting access to special merch. So Donata, talk to us about some of the tricks and trips that can come with offering utility to consumers.
Yes, depending upon how the NFT attaching the utility is presented to the public, it might trigger an issue under an Italian piece of law which governs price competitions, which defines price contests and also price operation. Price operations are basically promotions in which the price is attributed in case of a purchase of a product or service. So it's really a broad definition, and in principle, depending upon how the utility is presented, so for example, if the consumers are invited to buy the NFT in order to receive 1 free year of cookies, in principle, it might be regarded, all these mechanics might be regarded as falling within the scope of this definition. And in this case, several fulfillments and restrictions would apply, some of which might even be not compatible with the NFTs environment. So it is an open issue. However, in this case, the fact that the cookies are digital is of help, because there is an exception of the decree which can be used to exclude basically the application of these rules. In general, besides these possible issues on price operations, the advice is always to check the utility attached to the NFT to exclude that it is somehow regulated, because in this case it might have been a problem.
Okay, so we're way over time. I want to be mindful of everyone else's time, so I'll just say very quickly, if you're going to give royalties to artists or anyone else, and you're going to try to put that into the NFT when you mint it, it's an exciting technology to be able to continue to pay artists and other people who might want to benefit from the sale of the NFT. But right now, it's actually not done by smart contract. It's something that's implemented by each of the marketplaces themselves. It's impossible to promise someone that they're going to get a perpetual royalty. It's impossible to say that the NFT will always get that royalty. It's dependent on what type of tech the NFT holder or seller can read. So be very careful about over-promising in your contracts that people are getting perpetual royalties there. And then just to sort of sum it all up, I want to have Alan talk a bit about some of the core advertising issues that have happened in this space and some of the watch-outs for brands. And then we really have to get off the stage.
Well, no, I'll make it really quick. I suppose the ASA is really focusing a lot on the advertising of crypto and sort of crypto assets, and a lot of you will be aware of the Arsenal Football Club case that sort of is fairly recent. But Guy and the team have probably helpfully put together some sort of top tips really when you're looking to advertise NFTs, and I suppose it's making consumers really aware that it is a crypto asset and it's unregulated and therefore unprotected, that they are of course subject to very volatile markets, and anyone watching the news in the last few months would be acutely aware of the issues with NFTs in that sort of space. To Valdir's point, capital gains tax may be payable on them, yeah, really to not assume that this is a market that people understand. It is very complicated.
Yes, and in the United States, we have additional information, which is if something is considered a security, which the SEC is increasingly claiming many non-fungible token projects are securities, you might have additional disclosure requirements, including how much money you were paid, depending on the project. We saw Kim Kardashian recently get in trouble for that. So a lot to think about. I want to be mindful of everyone's time, but thank you so much, and we're here for questions later if you have them. Thank you.